Good afternoon and welcome to another edition of the Daily Fix. This is the fourth edition for today. It's been a busy day, been a rather busy day, but there's a lot of work to do. So let us get into the business of the day. This evening, I want to poke holes in Gininda's evidence. You'll recall, my last two in the last few episodes that I made that I was talking about that I made. In the last two episodes that I made, I made mention of the fact that Gininda was saying this is a prosecution-led investigation. And I explained what a prosecution-led investigation is all about. A prosecution-led investigation, in short, is a prosecution is an investigation in which the prosecutors play a lead role. The ultimate decision lies with the prosecutors whether or not evidence is, rejected or accepted. That is what Gininda tells the court. It was a prosecution-driven investigation. That is the reason why he says, for instance, the theory that, there were no intruders was rejected. So the prosecution-led investigation, concluded or led to the theory that, there were no intruders, there were intruders in the house. Like Gininda has been testifying. But the way Gininda is writing his law exams, but Gininda had better know this if he's going to pass those exams. The way Gininda answers questions, starting with this prosecution-led investigation business. You see, he wants to attribute responsibility to somebody else. He calls himself a lead investigator. We have exposed that he was never a lead investigator. He was never the lead investigator in the Senzo Meyiwa matter. But then he styled himself the lead investigator. He attributes whatever decisions are made, for instance, to, this investigation being prosecution-led. For instance, the two theories that I've talked about. Another thing is, whenever he's asked a question, and I'm concerned with the line of questioning that, people like Ramusipil are adopting. Whenever he's asked a question, when you ask a question in law, right, you are asked about what you know, right? What you personally know, period, right? You are not going to say, well, in answer to a question, I will have to look into the investigation statements. Let me tell you why you can't do that. You can't do that because that information contained in the investigation docket was compiled by somebody else. You are not part of the compilation of that docket. So you are saying, well, if I refer to the docket. In other words, you are actually saying you are going to rely on hearsay evidence. That is hearsay evidence. Any evidence that a person does not have personal knowledge of, right, that you personally heard, right, or you personally came across, becomes hearsay evidence because the docket statements are compiled by somebody else, and you merely read them, and you are being told. In other words, you are testifying to something that you have been told. That is the second leg of it. I have already said, he says this is a prosecution-led investigation. Attributes everything not ultimately to himself, but points away to say, well, whatever happened in this matter, ultimately it was a prosecution-led investigation. But then what then do the police do in a prosecution-led investigation? It doesn't mean that the prosecution, just ignores, the input from the police, because the police are on the ground doing an investigation, right? So that even if the prosecutors play that lead role, the police have the better expertise in terms of the investigation skills and so on. So Gininda must have been part of this process to make these decisions. it is not just a question of the prosecutors just, making the decisions alone and whatever input he comes up with being ignored. So whenever he answers questions, Gininda wants to lecture these lawyers. He's lecturing these lawyers. And these lawyers are letting, Gininda, a student of law, lecture them. They're supposed to be qualified advocates. How do you take lectures from a student of law like Gininda? So they ought to stop him and say, Gininda, right? For instance, let me give you an example. Advocate Ramusipili said to Gininda, you see, there was an identikit or a sketch compiled by the police, right? Because allegedly one Thabang Makeleni had seen the accused persons at a filling station not very far from Kolu Kumalo's mother's home, and also outside the Kelly Kumalo's mother's place on that evening. So he concedes that an identikit based on Makeleni's explanation was compiled, right? Remember, this was in the evening. You are seeing people for the first time. How reliable will such an identikit or sketch be? It is as if Thabang Makeleni had all the time to look at these people, and it was at night. He even goes to the extent of saying he saw false teeth, gold teeth rather, gold teeth in accused number two's mouth. I don't know whether accused number two had his mouth open for Thabang Makeleni to identify that he had a gold tooth, or I don't know. But it was at night, and they compiled an identikit based on the observations of Thabang Makeleni, who saw these people at night, and he was seeing them for the first time. And there's that doctor who says accused number two, Bongani Ntanzi, has never had a gold tooth in his mouth. So that evidence immediately falls away. Now, when Gininda is asked why, right, then was after the arrest of Bongani Ntanzi, why was an identification parade not conducted? Right? These were the people in the house. The house was lit. Makeleni says he saw this man somewhere in the dark. The house was lit apparently when these intruders came into the house. No identification parade of the first suspect, the first arrested suspect, being accused number two, Bongani Ntanzi. No identification was ever done for any of the people in the house to identify him. You see the contradictions in this investigation. These are the worrying, inconsistencies in the evidence that Gininda gives to the court. And frankly speaking, his manner of answering, you know, he must be he's probably the most articulate policeman who has ever come before the court and testified in English. But for purpose of evidence and law, the English amounts to zero, right? We are here interested in facts and hard facts and not evasive answers, right? That require long explanations. Answers are not explanations. Once you give a witness an opportunity to explain, he'll explain away everything. If you ask a witness, let me give you an example. If you're a prosecutor and you ask a witness, did you rape this victim or not? Right? The person is supposed to say, yes, I did, or no, I didn't. Right? He is not going to give you an answer to the effect that, yes, I did, or no, I didn't, because of blah, 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 blah. You see, because that explanation then dilutes and totally makes a mess of, the answer that he's giving. It's got to be a specific question with a specific answer. Now, Gininda has been evasive because he gives long explanations which the defense is just listening to and taking, and so that if you let a man run in circles like that, you give him the opportunity to be evasive, and ultimately, you see, the damage is done because he does not actually answer your questions, right? He makes an answer and qualifies that answer with an explanation. That is what Brigadier Gininda has been doing throughout the Senzo Meyiwa trial. And these are the holes that I'm trying to poke in his evidence. Once more, for this evening, let me say thank you for all the subscriptions that I'm seeing. Thank you for all the views that I'm seeing. Let us go for 2K subscribers. We are almost there. We are almost there. With your support, right? With you behind me, I can make it. We'll go to 2,000 subscribers in a few days' time. I know it will happen. And we'll go beyond that because the sky is the limit on the Daily Fix. Thank you and have a wonderful evening.